Good day from wherever you are hearing the sound of my voice. My name is Barrister Dr. Janet Fashakin. I am a practicing attorney and the CEO of Fashakin and Associate PC. We are located in New York and we have been in practice for over 2 decades. We love what we do, and we know that our clients love us a lot. I come to you periodically whenever I see something that I think might be bothering or boggling your mind, as somebody who has filed a petition to become a citizen or a green card holder in the United States of America. I recently talked about I-130 and all the nitty-gritties there. I'm continuing the I-130 today. And what I am going to be talking about at this time is when the person who petitions for your I-130 dies, then what happened to the petition? Is that the end of the petition? Can you still do something about the petition even though the person who filed it for you has died? When we talk of this petition, we're talking of the I-130 relative petition that husband and wife can file for each other, daughter, son, and parents can file for each other, and even brothers and sisters can file for each other. That is what I'm talking about. Originally and historically speaking, the rule is that the approved petition dies with the petitioner. That once the petitioner is dead, forget it. You have to look for somebody else. You have to start all over again with another person. But it starts still the law as of today. That has in a way changed. Recently, somebody was asking me the other time, saying, Barrister, I just want to know if my petition for my father is still valid, even though my father is dead. Yeah, like I said, upon the death of the US citizen petitioner who petitions for you, the approved I-130 is automatically revoked, and that is pursuant to the law that you can find in 8 Code of the Federal Regulations, Section 205.1A, subsection 3, subsection I, and subsection C. The beneficiary must affirmatively request reinstatement of that revoked petition pursuant to another section of the law. And that other section of the law, which is 2041, it was enacted to help certain beneficiaries. According to the U.S. Citizenship and Immigration Service, that section of 204I of the INA can still apply to a case that was revoked. So the revocation does not mean that your case is over. Automatically, when the person dies, the law triggers and revokes your application, but you have to now take a step further. You have to request that the case be reinstated. Revocation and reinstatement simply provide the procedural mechanism that will let the immigration verify whether that section 204I applies to your case, and if it does, for them to decide whether to exercise discretion favorably. It's at their discretion. They can reject you, they can approve you, and that's why prayer is important, and God will grant you favor before their sight. When the beneficiary requests and is granted Section 204I relief, immigration reinstates the approval of the petition so that the beneficiary can continue the process of obtaining lawful permanent residence, which we call green card. It's a technical difference because of how the law is written and other laws and regulations that existed before that 204 I came into existence. Now, processing times may vary depending on where your file is located and other factors. Immigration will consider the facts and humanitarian considerations of your particular case. Now, if it is reinstated, then you are able to file for adjustment of status to lawful permanent resident or consular process. If reinstated, then you will need to obtain a substitute sponsor who will need to file a form I-864, which we call the affidavit of support. Okay, because remember, the person who filed for you is already dead, so you have to look for a substitute person that can put all these papers down and say, yes, he's going to support you, and he has to back it up with an affidavit. When a petitioner's visa petition is pending and she passes away, USI will continue processing the petition if the beneficiary requests and is granted that section of the law. So I'm repeating that. But the beneficiary needs to make a written request to have the immigration apply that section of the law to their case. So basically, all hope is not lost. If somebody who filed for you is dead, but they will not continue processing your application until you make that request. And they will send you a bunch of things that you have to show why they should continue it. And part of it is the affidavit of support, because America is not looking for somebody that is coming over here and be taking benefits illegally or unlawfully without somebody standing in and saying you can punish me for it. If she does that, okay, that's essentially what that affidavit of support is all about, okay? That if you incur any problem, the person will step in and will be the one to be sanctioned for it. And also the person will be in the position to take care of you, provide all your financial support. So if you can get somebody like that, you can put his livelihood on the line to say yes, it will support you. They will continue your application. Now, furthermore, when it comes to that affidavit of support requirements, most immediate relatives and family-based immigrants are required to have it. In some cases, the beneficiary's work history or other factors also may make it unnecessary. Because up until that time, if you have been able to get a work permit, like if it's your husband that filed for you, that is now dead, and you have a work permit and you are working, you'll be filing your taxes and you make enough to support yourself and your dependent children, then you may not need anybody to file that affidavit of support for you. Now, for those who are substitute sponsor, to be a substitute sponsor, an individual must be a US citizen, a naturalized citizen or lawful permanent resident, and must be over the age of 18 years. It has to be your spouse, your parents, your mother-in-law, your father-in-law, your sibling, your child, your son, your daughter, your son-in-law, your daughter-in-law, your sister-in-law, your brother-in-law, your grandparents, your grandchild, or legal guardian. The list is very wide, and if you are really serious, you must be able to get one of them to file for you if you have not been making enough for them to waive that aspect. Now, as is the case with all applications for lawful permanent resident status, the grant of such status requires a favorable exercise of discretion by immigration. Relief under that section of the law, which is 204I, is not an entitlement, like I said, but a matter that Congress has entrusted to the Department of Homeland Security discretion. Immigration has discretion to deny relief under that section if they find that granting relief under it will not be in the public interest. As with other forms of discretionary relief, exercising discretion means weighing positive factors against negative factors to make a decision. In addition to meeting the basic requirement for that section, your request must warrant a favorable exercise of discretion, meaning, that the pros in granting your request outweighs the cons. However, immigration knows that section is intended to help people who are put in an unfortunate position because of a sad event that was beyond their control. The intent of the law is a very strong pull factor that weighs favorably in the exercise of discretion. So if you've not been a criminal, if you have not done anything that will make them to want to cut you off, they will regularly agree to reinstate and to continue your application and then to be able to give you your green card. There are other considerations when working with that section of the law that I've not mentioned. And since this process can be very confusing and document intensive, you will be best served by consulting with an experienced immigration attorney to discuss the process and eligibility requirements so that you don't shoot yourself in the foot by saying something or doing something that can make them to permanently ban you from being able to benefit from that section of the law. And I hope that somebody that will listen to this lecture will benefit from it, if not now, maybe later. Or if you know somebody who is under this category, the petitioner has died, and the person doesn't know what to do anymore, you can share this video with the person. Help me to share it. You never know who can benefit from it. This is immigration. This is US immigration. Please help me to share. Help me to like my video. And until I come your way again to sensitize you to what may be trending in immigration law, I remain yours truly, Dr. Janet Fashakin, Esquire. I am the CEO of Fashakin and Associate PC. We are located in Jamaica, New York, and our phone number is 718-441-6056. 718-441-6056. And the email address is janetfash@gmail.com. janetfash@gmail.com. I thank you for listening. And again, please remember to help me to share so that it will be worth this periodical lecture for you and for others. Thank you. Have a nice day and happy new month. Today is May the 6th, 2024. So the month is still very early. So enjoy the rest of the month until you come your way again. Thank you.